The U.S. Supreme Court will hear a case on Wednesday that has the potential to overturn Roe v. Wade. The case is a challenge to a 2018 Mississippi law, which bans abortions after 15 weeks of pregnancy. The Supreme Court has never let states ban abortions before approximately 24 weeks. That's roughly when a fetus can survive outside the womb. Former Vice President Mike Pence is speaking out today at the National Press Club in Washington. He is advocating for the end of Roe v. Wade.
I came here today to speak about right and wrong, to say life is a human right, and urge the Supreme Court of the United States to choose life. As we stand here today, we may well be on the verge of an era when the Supreme Court sends Roe versus Wade to the ash heap of history where it belongs.
For more on this, I want to bring in Linda McClain. Linda is a law professor at Boston University. Professor McClain, welcome. Thank you for being with us. What are the constitutional questions being asked in this case?
Well, the court accepted review on the question of whether all pre-viability bans on abortion are unconstitutional under Roe and Casey. And Mississippi's law, as your segment pointed out, clearly would be unconstitutional under the current state of the law. Mississippi is arguing that it's time for the court to overrule Roe and Casey because there's no basis in the Constitution for right to abortion. And Jackson Women's Health is arguing that there's no good reason to overrule Roe and Casey. Mississippi's law is clearly unconstitutional under Casey and Roe, and that Mississippi has not offered persuasive reasons to do so.
So a lot of people are looking at this, Professor McClain, as an all-or-nothing case. The Supreme Court will either uphold Roe v. Wade or overturn it. But could the court navigate this decision without such a dramatic outcome?
Well, 30 years ago, when the court decided Casey, a lot of people thought maybe the court was going to overturn Roe. And what the court did instead is claim it was upholding the central holding of Roe, which is a woman has the right to choose before viability, but at the same time, it dramatically cut back on Roe. It's possible the court could say 30 years later, they're affirming Casey, but revising it in some way. It's a little hard to see that path, but they might say that viability should no longer be the line because 30 years of scientific developments have taught us things about fetal pain or methods of abortion. And so as long as it's not an undue burden for a woman to have 15 weeks or to terminate a pregnancy, given that 90% of abortions take place during that time period. So they could claim that they're not officially overturning Roe and Casey, but significantly cut back on the import of those cases. That's one avenue, short of just outright saying these cases are wrong and it's time to let them go. Or they could strike down the Mississippi law and say they clearly violates Roe and Casey, but you need at least 5 justices to do that. And you have to have the 3 liberals plus Roberts plus at least one of the other justices.
Well, hold that thought because I do want to ask you about the new makeup of the court in just a moment. But first, abortion rights advocates say that if the court does overturn Roe v. Wade, 26 states in the country would likely move to ban the procedure. So how would that work legally? Could there be additional challenges to that? And what steps would be taken state by state?
Right. Well, if Mississippi prevails, then the court would be concluding that there is no fundamental liberty protecting the right to abortion, and abortion restrictions would be subject to the lowest form of judicial review called rational basis. And so, excuse me, states would have a lot of latitude for what they chose to do. And as you point out, many states already have restrictive laws. Some states, like Massachusetts, where I live, already have laws like the Roe Act trying to codify Roe and protect the rights of pregnant persons. So it's going to be a checkerboard. And even though Mississippi claims that states could work things out in the democratic process and have compromise, the likelihood in the more conservative states is an extremely restrictive abortion regime with a lot of consequences, particularly for poor and rural and women of color.
And so I want to get to the makeup of the bench now, as you brought up earlier, because the perception of this case seems skewed since the bench now has a conservative majority after former President Trump's appointments, although we should use that word lightly because the judges themselves obviously don't think of themselves as, ideological. But, is there a scenario where Justices Gorsuch, Coney Barrett, and Kavanaugh surprise people and don't vote to overturn Roe v. Wade?
Well, in the Fulton case that was decided at the end of last term was about foster care services in Philadelphia. Some people thought the court would overrule a controversial religious liberty precedent, but Justice Coney Barrett did not do that. And she said in a concurring opinion, what's the standard that's going to take its place? We don't need to do this right now. It's possible that she might think we're not ready to overrule Roe and Casey yet. But find some way to maybe cut back a little bit. I think people need to watch tomorrow to see what kind of questions Justice Coney Barrett asks. I mean, I think Mississippi is pitching some of its arguments directly to her because they're arguing that women don't need abortion rights, that we've had tremendous progress in America on gender equality, and what Roe was worried about, the distress of unwanted pregnancy, or what Casey claimed, that women need reproductive self-determination to participate in the lives of the nation. That's just not true, and we're not going to harm women's equality by cutting back on abortion rights. Coney Barrett is a mother of 8. They might be thinking, given her opposition to abortion that she's publicized before being on the bench, maybe this would be an appealing argument. And but on the other hand, she may not be wanting to go that far in only her second term on the court.
And so, Professor, when can we expect a decision from the Supreme Court? And also, do we think that the court of public opinion weighs on the justices' minds at all? Because we know from polling that overwhelmingly most Americans do want, abortion rights to continue in this country. Does any of that have any bearing on the justices? Are they judging this case on its, on its terms in a vacuum?
Well, Tanya, there's this notion of stare decisis, which you should adhere to precedent, and there's certain circumstances in which it's extremely important to do so. Casey claimed it was adhering to precedent, and there were a lot of compelling reasons, including sociological ones, about the status of women in our country. It's now 50 years after Roe, and Chief Justice Roberts might think that there's reasons to adhere to precedent. There might be concern about the political fallout, even though, as you say, the court supposedly doesn't look to that. And I'm sure that some justices on the court are going to be very mindful of how it will look if this court with a conservative supermajority strikes down Roe versus Wade and Casey with the power that it has now.
All right. Well, Linda McClain, law professor at Boston University, thank you for joining us. We appreciate your insight.
Thank you.